And I'm going to turn it over to our judges now.
Hello, Nebraska. Congratulations on making it to finals. And thank you for all the work that it took to get you here. My name is Caitlin Johnston. I am an attorney in New York City. I'm joining you from my apartment in Manhattan. And I am also a We the People alum. So I did this when I was in high school, but did not make it to nationals. So you've already bested me. We'll finish our intros on this side and then ask you to introduce yourselves.
Good afternoon. I'm Ed Murphy. I'm a Superior Court judge in Tacoma, Washington. Offer my congratulations to you as well, and I look forward to hearing your presentation.
And I am Edward Volpe. I'm an attorney in Denver, Colorado. I offer you my congratulations as well, and my congratulations to your teacher as well. Job well done. I look forward to your comments.
Would you please introduce yourselves and your teacher?
I'm Olivia Brem.
I'm Pratham Soni.
I'm Kyle Waddell, and our teacher is Kevin Ruby.
Very good. Hi there. Great. Okay, so you already know the question. We're doing question 2. I'll read it all the way through. When I'm finished, you can begin your remarks, and that will start the time. A Bill of Rights is what the people are entitled to against every government on earth, general or particular, and what no just government should refuse or rest on interference. Do you agree or disagree with Thomas Jefferson? What are the advantages and disadvantages of a national Bill of Rights as compared to state bills of rights? And what are the differences between positive and negative rights, and which are more important to the preservation of liberty? You may begin.
We agree with Thomas Jefferson that no government should refuse or rest in interference of a Bill of Rights. A Bill of Rights is necessary in order to ensure that governments do not deny their citizens basic and fundamental rights. This is why many countries around the world, following America's example, have implemented similar legal frameworks. The most compelling examples of this are Germany's Grundgesetze, Canada, UK, and South Africa's Bill of Rights. These pieces of legislation set forth the rights in which the government cannot infringe and must adhere to. However, in many ways, bills of rights can cause issues when they become the only rights which are protected. Although the Ninth Amendment claims that rights cannot be denied by omission from the Bill of Rights, in many ways they sometimes are. Look, for example, at segregation and slavery. These rights of African Americans should have been protected with constitutional implementations or constituents implementation. But despite this, the omission of rights of equality, the rights of equality in the Bill of Rights gave leeway for lawmakers and slaveholders to discriminate and enslave for almost 100 years.
The advantages of a national Bill of Rights as compared to a state Bill of Rights is that it can be incorporated into the states when it needs to be. The Supreme Court has routinely used the 14th Amendment to incorporate specific rights located within the Bill of Rights to the states so that such a violation cannot occur by a smaller state government. This is showcased in examples like Mapp v. Ohio, incorporating the exclusionary rule to the states, Brown v. Board of Education, preventing segregation in state-sponsored public schools, and Gitlow v. New York, incorporating the First Amendment to state governments. A national Bill of Rights creates consistency nationwide and ensures that all citizens are guaranteed equal protection under the law. In Brown v. Boyd, students who were discriminated against based upon race were protected by federal law where the state law had failed. Not all legislation is legal, a prominent example being Jim Crow's violation of due process and equal protection doctrine, and a national Bill of Rights helped prevent states from violating citizens' rights.
While the National Bill of Rights has its advantages, they fall short in other ways compared to a state Bill of Rights. A disadvantage of a National Bill of Rights is that too much centralized power has the ability to actually breach citizens' rights. The foundation of the United States was based on the rights of the local states because they were not being represented by the British government through laws such as the Tea Act, Sugar Act, and Stamp Act. In the formation of our new nation, the concept of limited government was highly emphasized. Beyond this, a state Bill of Rights is better equipped to handle the rights of individual communities. There are delegated and reserved powers to federal and state government because a state government is better equipped to handle local issues like education and licensing. For example, communities of Mormons who practice polygamy do not have the right on the national scale. In Reynolds v. United States, the Supreme Court unanimously declared polygamy to be unprotected by national law. This demonstrated a National Bill of Rights is less equipped to understand the local needs and rights of citizens in comparison to a state Bill of Rights.
Positive rights are the possession of freedom to act upon free will, while negative rights are freedom from interference. And while both are extremely essential, negative rights hold greater importance in preserving liberty. Positive rights are the freedom to do something, whereas negative rights are the freedom from something, from an entity of control. In order to preserve liberty, there has to be room to further expand the protection of rights and freedoms that have yet to be protected. And in order to do that, there must be freedoms from control. Many of the rights in the Bill of Rights are negative rights, such as the First Amendment and the 14th Amendment. While positive rights are important to expanding liberty, they do not preserve it, and positive rights cannot exist without the protections of negative rights and liberties. In the court case of Obergefell v. Hodges, gay marriage was legalized through the Equal Protections Clause of the 14th Amendment. While the right to marriage was a positive right, it was able to be ensured through the negative rights of equal treatment under the 14th Amendment. The right to equal protections under the law and due process in the 14th Amendment ensures that all positive rights are guaranteed to all constituents. In this way, negative rights are quintessential to the preservation of liberty.
Great, thank you. Please put your notes away. We'll move into follow-ups. Let's start with what limits, if any, might be placed on rights that are listed in the Bill of Rights. And maybe we take free speech as an example, please.
Specifically, when we look at a multitude of court cases, there have been examples where the Supreme Court has put limitations on the right of free speech. For example, we saw in cases like Brandenburg v. Ohio that hate speech is protected, but speech that actually causes violence or that might incite violence is not protected. And so as a result, we see that the Supreme Court has stated that when speech is going to cause violence, they don't actually allow that under free speech. But if the speech is either hate speech or is not going to cause violence, then it is allowed.
It's the clear and present danger doctrine, where speech presents a clear and present danger, like in Schenck v. United States, where they said his speech was it was against the the best interest of, it was like compelling state interest of the national government. It was in wartime, and he was saying that we shouldn't be in this war, I believe, that it presented a clear and present danger to the well-being of the nation as a whole.
I'd also like to add that as my colleagues talked about, like the limitations, there's also areas where there aren't limitations. For example, New York Times versus United States, the New York Times said that they wanted to limit the amount of speech that someone could have, but they wanted to allow these illegal documents that were being handed to be presented to the public. And therefore we see that the United States, although they do limit some rights, they also do not limit other things, such as allowing and posting documents that have been obtained illegally.
That also just sparked another thought of how libel and slander are also not protected by the First Amendment freedom of speech.
What is the difference, if any, between rights added through the amendment process and those established by a court decision?
Well, I would actually say that I think a lot of court decisions are based off of rights given in the amendments. I know that a lot of times in Obergefell v. Hodges, they use the 14th Amendment, the Equal Protections Clause, and due process. They use that to incorporate national rights at the state level. So they use the amendments in those court cases a lot of times in SCOTUS cases.
Additionally, I would say the specific difference between the two processes is, number one, the ease of which they can be changed. Supreme Court cases are easily interpreted differently depending on the court's specific case that they're dealing with in that circumstances. And whenever new cases arise, that right can be interpreted differently and therefore applied differently. However, with amendments, even though they can be interpreted, the permanency of that legislation is much more than, say, if it was a legislative act by Congress or a Supreme Court decision, because it's much harder to overturn that as a whole. However, again, because these amendment rights are interpreted by the Supreme Court, they can also be overturned semi-easily.
So yeah, to extend on to what Olivia said, I also think a court case like Roe v. Wade shows you that there's protections, such as your right to privacy, that are added through the Bill of that are extensions from the Bill of Rights, and ultimately those are extended to the peoples, and they're just interpretations of rights.
Yeah, people are trying to overturn Roe v. Wade even today. A court case, when they make a court case, the Constitution hasn't changed, but our modern day interpretations has changed, and people are always going to have this tension of on these hot button issues of what we should do or what we should not do based upon the cultural setting. And so the constitutional rights aren't supposed to change, whereas SCOTUS decisions can be overturned and changed.
You talked about the difference between the powers of the states and the federal government at the time of the founding of this nation. Is it possible at the present time for a state to make legal something which is a federal crime?
I think it is, we've seen through the legalization of marijuana that certainly is possible. even though it is still both a federal crime to partake in like the distribution of marijuana and so forth. Marijuana dispensaries do exist in states where it is legalized, such as Colorado, Washington, South Dakota even. And so as a result, it is simply the enforcement of the law by the federal government that either really dictates the legality of something. Because even though it is illegal at the federal level, the non-enforcement by federal officers in those states means that for all intents and purposes, it is legal in that state.
Let me ask a follow. Oh, go ahead.
Oh, I was just gonna say, back to the abortion issue. Roe v. Wade at national level, you're not supposed to be able to, like, all women are supposed to be able to have access to abortions. However, in like I believe in Alabama just recently, they passed pro-life legislation where they outlawed abortions. So it doesn't align with the national scale, and the way that you overturn the state, the way you overturn like state laws that don't align with the national scale is through judicial review and through the SCOTUS.
And moreover, a more recent issue that's happening today is the idea of denying healthcare access to transgender individuals. We've seen this as more southern states are trying to stop transgender individuals from receiving healthcare in general, and more specifically gender changing surgeries. We've seen this because we've seen court cases in which protect a person's right to healthcare and protect them, or not healthcare, but like protect them against discrimination. But we've seen gender-based discrimination happening more recently in the status quo.
Would you like to ask a follow-up, Judge
Yeah,
Volpe?
Yes, as long as we're talking about the difference between state and federal power, can the federal government compel state authorities such as police to enforce federal laws?
So when it comes to the federal government's interference in sort of federal or in sort of state jurisdictions, there are several instances where the federal government cannot compel state authorities to do so. When we look at areas like safe cities on the West Coast, for example, places like San Francisco and Los Angeles, where the police departments don't have to cooperate with federal authorities such as immigration and customs enforcement, because they've set specific policies in which the federal government, in which they say, we don't believe in this ideal, so we're not going to cooperate with what this federal agency is doing. Now, on a broader scale, the federal government can ask for cooperation from these different local forces, but they can't necessarily compel it.
Yeah.
To extend onto what Kai said at the end there, state police and local police officers operate within their state itself, so they have to operate and enforce the laws of the state. So they don't necessarily have to comply to the national laws, because they're inherently attached to the state and local ordinances that's their power, such as like in our hometown, Lincoln, Nebraska, right? Like the Lincoln Police Department, they're going to enforce the rules that are in Lincoln and Nebraska generally.
Like city ordinances. And there's also like the National Guard, which is in each state. We have the Nebraska National Guard, but then we do have the State Patrol, which are two different things. The National Guard is a military branch, whereas the State Patrol is more for state ordinances too.
Under what circumstances could someone lose the rights that they have in the Bill of Rights or the Constitution?
I think several of them what we see is through incarceration. For example, the 13th Amendment, has that you're not allowed to have slavery as be a slave except for as a punishment for a crime. And so we see that there is unpaid labor that happens in areas like imprisonment. Furthermore, they're not allowed to vote also after incarceration in many states. And so as a result, there is some ability to restrict the rights after being incarcerated due to different sort of loopholes that are in the Bill of Rights.
Yeah, I would also say that kind of just along with the idea of civil disobedience, like even if we don't agree with the law, there's the idea of not following it, but being in prison for that, it kind of shows that some people have their rights taken away unjustly. And I think you also think about like not all laws are just. May I finish my thought?
You can finish your thought.
I was just gonna say, what was my train of thought? Oh, that not all laws are just. You think about Jim Crow, Rosa Parks, Martin Luther King, they all went to prison and could have lost their rights unjustly. So people can lose their rights that way.
Great. We'll call it there. Take a deep breath. Great job. Excellent job, guys. Wow, I felt like I just was in a college level course on the Bill of Rights. That was, you showed immense confidence in building off of each other. It's very natural. It's as if you rehearsed every single answer, but I know you didn't know what we were going to ask. So that just means you were that much more prepared. So great job. I thought you packed a ton in. My piece of constructive feedback would be you jammed maybe too much into your prepared remarks because you were going so fast that it's a little hard to follow. So consider maybe trying, ditch a point if you've already responded to the question. Everything you said had value, but it is going to be more effective if you can slow it down so that somebody can keep up with all the ideas you're throwing at us. But really excellent job. And with the follow-up, we actually love a fast-paced follow-up because that keeps the conversation going. And we threw a bunch of different subjects at you and you were ready for each of them. So bravo.
I would echo that. Very well done. And also the comments about the prepared remarks. You did have an awful lot in there. And that's good, but it went really, really fast. And so I felt like I was kind of hanging on the bumper of a car as you were driving off at 60 miles an hour. And some of those things you can tease out through through the questions. And obviously you don't know what the follow-up questions are going to be, but you were ready for the ones that we threw at you, and you brought a lot of different sites and examples and modern day examples, talking about the transgender youth, sanctuary cities, things that we haven't heard about from other groups to date. So really well done. Congratulations to you and to your teacher or mentor, and keep it up.
I would echo those comments as well. I thought you did an excellent job of demonstrating an understanding of what is a terribly difficult question. We could go on for the next 2 days talking about this question, and I think we would have plenty of material to go over at the time, but you came up with some of the more important precedent, and the reference to Germany and the reference to the development of freedom in an age of slavery, and the importance of the 9th and 10th Amendments to the founders, who basically said, we're going to list some rights, but these aren't all the rights of the people. And the 10th Amendment clearly contemplated that the states would have their own constitutions and hopefully bills of rights, because it reserved all other rights to the states and to the people respectively. With regard to the limits on free speech, I thought you did a good job with Brandenburg. You came up with the Schenck case from World War I. I thought that was interesting. You mentioned libel and slander and the efforts to overturn Roe and those kinds of things that people are arguing about whether rights should be recognized. Certainly the right to abortion and contraception is being debated at the present time, even though recognized by the court. The safe cities, I thought, was an excellent reference, in that some states have simply said, we will not report aliens to the federal government. There is a specific US Supreme Court ruling on anti-commandeering, which is the principle being discussed, and that's Prince, P-R-I-N-T-Z versus US, which said that the state authorities could not be forced to do background checks on the sale of weapons, even though the Brady Bill from the federal government did mandate background checks. But again, I just, good on how you can lose rights as a citizen and how perhaps they can be restored. I can only say I commend you for the hard work you've done for 2 semesters. I commend your teacher for how well they brought you along. Thank you for this presentation.
Thank you very much for judging.